Okay, so we'll probably kick off now. I think people are still joining, but we've got enough that we'll get started. Welcome, everyone. It's brilliant to have so many of you here today online for what is becoming a very popular type of session for the Society of Construction Law. So this is our second webinar on construction case law updates, and this seems to work well for lunchtime format. So thank you everyone for joining us. I'm Lauren Whitehead. I'm a partner at Anderson Lloyd, and I'm also a council member with the Society of Construction Law. So welcome to our non-member guests and to our new members joining us today. And thank you to Minter Ellison for hosting our webinar. We really appreciate your technology. So I believe that the host has set the function that attendees cannot be heard or seen, but if you could just please mute your everything, your video and your mic, and just make sure that it's muted so you can enjoy your lunch and listen to our presenters without interruption. I'm just going to first talk some SCL notices. So we have a super busy September. We've got Michaela Cook presenting next week on Is Concurrent Delay a Chimera? Some of you, like me, may not know what that was or how to pronounce that. So it's in Greek mythology, this is a monster with the head of a goat and a lion, apparently. So probably a good description for concurrent delay. So Michaela will be covering several essential practical topics in her presentation. And if you haven't already registered for this meeting, please do so without delay because we want to finalize our arrangements for that. On the 24th of October in Wellington, we have a breakfast meeting with the Minister, Chris Pank. He's the Minister for Building and Construction. Registration is open for this session that's being held in Parliament, and Council are working through some salient questions for the Minister. So this promises to be an amazing session and one that we're really delighted to be hosting. So if everyone could please register promptly for those who want to come, as we'll be opening this up to a wider audience of construction professionals as well. So now to our webinar for today. So I'll introduce each of our speakers in turn, and we're going to save questions to the very end so we can ensure that we get through all three of the interesting case updates in the hour. So please use the Q&A function on the platform, and if you have any questions, and if we have time, then I'll ask some questions at the end. And you can refer to our flyer on the website for a link to all of the cases being discussed, together with a full introduction of all of our speakers. And there will be a recording of today's session posted in the members area. So welcome to our first presenter, Madison Doby. Madison is a senior associate in the major projects and construction team at Denton's in Wellington. She specializes in construction law issues arising in the entire life cycle of a project, from front end and contract negotiation to disputes. Madison is going to be discussing the famous case of Obrascon in delay claims under the FIDIC forum. Obrascon challenged, when does the timer start for notification? Madison, are you able to please share your screen and take over from here?
Yep, I can do that. Can everyone see that? Nod, thumbs up. Yes,
yeah, good.
Cool. Thank you. Cool. So thanks, Lauren. Good afternoon, everyone, and thanks for that introduction. So today I'm going to talk about a recent case law update on the interpretation of notification clauses, specifically under the FIDIC forms, but also relevant for the interpretation of similar clauses under equivalent forms of contract. I'll just change my slide. The specific issues that we're talking about today is when the timer starts to run for the purposes of notification. So this is the scenario where we have a clause that says something to the effect of, if the contractor considers itself to be entitled to an extension of time, then the contractor must notify the principal within X days after becoming aware of the event or circumstance on which the claim is based. So the question then becomes, what is the event or circumstance that the contractor has to be aware of? Is it the delay to the works, or is it the underlying event which causes the delay? In other words, the variation or the inclement weather or the like. So Obrascon, which is a case that some of you might be familiar with, is a case from 2014. which held that the incurring of actual delay was the trigger for when time would start. But today's case that I'm going to talk about, Panther and modern executive systems contracting, contradicts this position. So to provide a little bit of context to the Panther case, we need to kind of briefly look at Obriscon. The Obriscon case takes us to Gibraltar, which is in the south of Spain, a very small British overseas territory, and located at the very bottom of the Iberian Peninsula. It's absolutely tiny right here in the middle of the Strait of Gibraltar. And despite being a very, very small area, it provides the backdrop for one of the main cases for time bars under the FIDIC suite. And if you've done any sort of, disputes around FIDIC, you've probably come across it before. So the project itself was based at Gibraltar Airport, which is a bit of a strange setup, but it's quite interesting from an infrastructure construction perspective. It's also one of the things that the territory is famous for. So there's a street called Winston Churchill Avenue, which is the main road south through the area, which intersects with the airport runway. So basically, whenever there are airport movements on the runway, congestion was being caused on either side of the runway, and you can see the road intersecting there and a plane coming through. So quite an interesting setup. So by 2005, Gibraltar had resolved to address that issue by running a dual carriageway road eastwards along the edge of the runway on both the north and south sides, and at the eastern end to construct a twin bore tunnel to carry the traffic, which would be under the end of the runway. And at this time, there was also quite a lot of investigation undertaken in the area around the physical conditions. This was kind of a particular concern because of the quite interesting and storied military history of Gibraltar, which meant that there was a high risk of contaminated soil. Also the fact that this was an operational airport, so fuel, oil, all sorts of kind of chemical compounds have been spilled over there for multiple decades. So all that to say, pretty high risk project, lots of potential for delays. Gibraltar invites tenderers. Obriscon is one of the tenderers, and eventually in 2008, contract signed for around £30 million. Contract adopted was the Yellow Book of the FIDIC suite, which is the version of the standard form in the FIDIC suite that is for where the contractor is performing design and build. Period of works was 2 years, completion date at the end of 2010, and delayed damages of £5,000 a day. So the key terms that we had under this contract, we've got clause 8.4, which is the extension of time clause under the FIDIC suite, sets out the grounds, the grounds on which the contractor will be entitled to an extension of time, and it expressly notes that the entitlement is subject to clause 20.1. So when we look at clause 20.1, and the text is on the screen there, but breaking it down a little bit, the requirements are, first, that contractor is required to notify where they consider themselves to be entitled to an extension of time. That notice has to describe the event or circumstance giving rise to the claim. That notice has to be given within 28 days after the contractor becomes aware or should have become aware of the event or circumstance, and failure to notify results in no liability. So we're in condition precedent territory. So that's the clause. Back to the project. The project was significantly delayed. 2 years into it, only 25% had been completed. Really long. The judgment goes into great detail about kind of all the issues that came up. Somewhat predictably, a lot of discussion about unforeseen ground conditions, things like that, given the what I said earlier about the physical conditions. But effectively, Gibraltar purported to terminate as a result of the failure to proceed with the works, and Obriscon commenced proceedings for both wrongful termination and also seeking various extensions of time. There's a fair bit of discussion around termination, and the court goes through a fair bit of authority on whether or not the standard clause in FIDIC requires a serious or repudiatory breach before termination right crystallises. Spoiler alert, the court held that it didn't. But there's also some discussion on service of notices and what constitutes service under FIDIC. Obviously not going to go into any of that because of time constraints, but if that's of interest, then encourage you to read the full judgment. So on the extension of time point, the court held that there were a potential of 7 days extension of time available to Obriscon, compared with many hundreds of days that were claimed. The court then turned to whether or not the 2 claims that comprised the 7 days were notified under 20.1. I should also just say that both parties agreed that the clause was a condition precedent, so that's not an issue here. So this led to the court asking the question of when has the event or circumstance arisen? When does the timer start? So to consider this question, the court first looked at when entitlement arises under clause 8.4. Justice Arkenhead, it was persuasive to him that the clause 8.4 entitled the contractor to an EOT where completion is or will be delayed by the clauses in 8.4. So from that, he arrived at the conclusion that the entitlement doesn't arise to an EOT until either when the underlying entitling event occurs and it's clear there will be delay, or when the delay actually begins to be incurred. And the contractor can give notice when it reasonably believes it will be delayed, i.e. when 1 on the screen occurs, which Arkenhead referred to as the prospective delay. But it doesn't lose its right to claim until it fails to notify 28 working days after 2 on the screen. So the actual delay, retrospective delay is how he framed it. So basically this means that the condition precedent doesn't, what he's saying is the condition precedent doesn't bite until the contractor is aware of the actual delay being caused or ought to have been so aware. So puts forward quite a useful example to illustrate how this would work in practice. So the example is a variation instruction is issued on the 1st of June to widen part of the dual carriageway well away from the tunnel area. At the time of the instruction, that part of the carriageway is not the critical path, but it's foreseeable that the variation will extend the period reasonably programmed for constructing the dual carriageway. It's not foreseeable, however, that it will delay the work. By the time the dual carriageway is started in October, it's only then clear that the works overall will be delayed by the variation. So what he's talking about here, although not in so many words, is that by October, it's clear that the dual carriageway is on the critical path. It's only in November that it can be said, however, that the works are actually delayed, i.e. the actual delay to the critical path has occurred. And in those circumstances, the court held that notice didn't have to be given for the purposes of 20.1 until there is actually delay in November, although the contractor could give notice with impunity earlier, say in October, but it wouldn't lose its right to claim until it failed to give notice 28 days after the November point. So that's Obriscon. The Panther and MESC case was released last year, and it takes issue with this approach in Obriscon. Project at issue was a high-rise residential complex in Dubai. There's a picture on the screen here, just because I'm a visual person. I like to have pictures. The contract used was the Red Book. So for projects where the design is done by the employer or the principal, as we would call it, but employer under FIDIC. So after significant delays, Panther terminated the contract in 2019, and it was completed by an alternative contractor. They then commenced proceedings to recover LDs and other damages for the delays, and MESC counterclaimed on the basis there was no right to terminate that had crystallised because the contract included a threshold for termination where once LDs reached a certain level, the employer could terminate. MESC basically saying, factoring in all of these EOT claims we have, the threshold hasn't been reached and you, Panther, can't terminate. So in the first instance, the court found that Panther was responsible for 306 out of 325 days of delay. So effectively, Panther was predominantly it was Panther's fault that the project had been delayed, but MESC had failed to notify under 20.1, so it had lost its right to claim. And in coming to this conclusion, the court applied 20.1 so that time for notification would run from the date MESC was aware of the underlying event. Then it came before the Court of Appeal. Court of Appeal agreed with the judge in the first instance, but also made some interesting comments about the Obriscon approach. So specifically expressly declined to follow Obriscon, principally because in the court's view, Arkenhead's reasoning would result in a possible scenario where the time for notifying under 20.1 would only start to run once the time for completion had passed and the works hadn't been completed. And this would be contrary to the purpose of notification clauses, prompt resolution of claims, all of that sort of thing. In other words, the court perceived that what Arkenhead was saying was that actual delay was the time for completion passing and the works not having been completed. But I mean, the problem with that is that really what Obriscon was saying? Not really. It's pretty clear from Arkenhead's reasoning that what he was meaning by actual delay was critical delay, not when necessarily the time for completion had passed. And this is pretty clear in the example that we talked through earlier, which is the point at which the time starts to run is when delay has been incurred to the critical path to completion. The court also made this quote that I have on the screen, which kind of makes it clear that that's what he's saying. He said, the above interpretation does not in practice necessarily involve a difficult mental exercise on construction projects where, as here, a critical path program, invariably electronic, is used, which can determine when delay is actually being suffered. So what he's talking about is critical path analysis, not waiting for the time for completion to pass before you can be said to have had actual delay. So just a couple final points. Where does this leave us? Both cases are not New Zealand cases. Obriscon is in the UK Technology Court and Panther is Dubai, but both are likely to be cited depending on which side of the fence you are on. But the misinterpretation by Panther somewhat undermines the persuasiveness of that judgment, I think. I would also submit that the Obriscon approach should be preferred. And the reason for that is relatively simple. Taking a step back, what is it that the contractor is being asked to notify? It's being asked to notify when it considers it is entitled to an extension of time, and entitlement to an EOT doesn't arise until there is critical delay. So if we adopt the Panther view, the contractor is having to notify of a claim and potentially lose its right to claim before entitlement to that claim has even yet accrued. Also, we can see how the Panther approach would result in significant over-notification of claims, which I would argue also undermines the efficacy of the notification clause. So, it ultimately comes down to, like all things in a construction contract, to the question of what is the risk and who does it make commercial sense to bear it. The risk here is, claims don't get notified, so delays don't get mitigated until after the delay has been caused. Under the Obriscon approach, that risk is shared. Under the Panther approach, the risk is entirely shifted onto the contractor. What I mean by that is, under the Obriscon approach, the contractor is still required to notify as soon as reasonably practicable, and there could be an argument that if it knows that critical delay is likely, the task is on the critical path, it's obvious that it's going to delay critical paths to completion, and it doesn't notify, and as a result the employer can't mitigate in some way, it would have otherwise done. The employer could conceivably argue breach and have the claim proportionally reduced, but the contractor doesn't lose its right to claim. So in that way, the risk to mitigate is shared. But if the Panther approach is adopted, the risk is entirely shifted to the contractor, and there's this presumption that notifying earlier would have changed the nature or extent of the delay through mitigation, which is, certainly not always the case. And, in my view, that doesn't make commercial sense because it, as I say before, it places the contractor in the position where it's losing its right to claim before entitlement to that claim has even accrued, i.e. before actual delay has been caused. So on balance, I think the obriscon approach makes more commercial sense from a sensible risk allocation perspective. But that's just my thoughts. So that's everything from me. It was a very quick hoon through those cases, but thanks.
Thank you so much, Madison. That was really interesting. I guess we can look forward to some future challenges to those cases. I'd like to introduce our second speakers today. We've got Matthew Ferrier and Charlene Fairnie. So they're building on the further learnings from the Gore Street judgment. That's the Body Corporate and Auckland Council defective building claim, which Charlene presented a snippet of in April. Matthew is a partner at Minter Ellison with a particular interest in litigation of major latent building defect cases. He's also a specialist in regulatory investigations and prosecutions. Charlene is a special counsel with Minter Ellison, specializing in defective building litigation. She acts for the full spectrum of parties involved in construction of residential and commercial buildings. Matthew and Charlene, if you'd like to start your presentation.
Thanks very much, Lauren. So hopefully you can all see the slide deck now on the screen. If we just went through the agenda slide, Charlene. While that's coming up, so further learnings from Gore Street, there's a couple of relevant decisions. Body Corporate 366567 in Auckland Council from March this year, I think, and then a more recent judgment in relation to the process for determining quantum. We've called it further learnings from Gore Street for a couple of reasons. One, because as Lauren said, Charlene did a session earlier in the year in April, I think, on some of the legal aspects of the case. And secondly, because what we wanted to do was not so much treat it as a case law update and share findings that might have a bearing on how other cases are decided, but to talk about a couple of aspects of the claim and provoke some thinking about those aspects of the claim, because they have a bearing, we think, on the way in which defective building claims against councils and others involved in the building process are advanced and defended. So I'm going to give a very brief overview or refresher of the claim and where it got to, and then two topics we wanted to talk about. Charlene's going to talk about proving actionable defects, and she's going to do that by reference to a couple of the fire defects which were pleaded, advanced against the council, but were unsuccessful. And then I'm going to talk a little bit about the way in which the plaintiffs approached remedial works and quantum, and where that's gotten to and how that might have a bearing on the way in which claims are advanced in future.
I might just start sharing, because I seem to not be sharing the same screen that I've got. So I'll just try and reshare it and see if we can get it to load properly. Just while Charlene's doing that, so the overview of the claim, I mean, a lot of you will have read the judgment or seen the news reporting about it. So Gore Street's a building in central Auckland. It's a 40-storey apartment tower. It was constructed between 2004 and I think 2006. At the time it was built, it was the tallest apartment tower in New Zealand. It remains one of the taller ones. I think it's been eclipsed by a couple around it. It's a pretty big building, 393 apartments, 533 balconies or decks, 13 commercial premises, a podium with a pool, level 3 canopy roof, basement car park. And basically the plaintiffs claimed that it was defective throughout. The claim was filed remarkably in 2014, almost a decade after construction ended and a decade after it had started, and a long time before the trial eventually happened. There were about 39 defects alleged when it was first commenced, and I could be wrong about this, but I think the claim value was in the low single-digit millions, or maybe like $11 million, a little higher than I thought. That was reduced to 13 defects by November 2018. And whilst it sat on the leaky building list in the High Court, it wasn't a traditional leaky building claim. So it was sort of conventional in terms of the allegation of duty, that the council owed a duty of care and others involved in the building process owed a duty of care.
but novel, at least we think, in terms of the nature of some of the defects and the evidential basis for the claim. Really, the leaky issues were secondary. There was very little evidence of water getting into the building. There were some claims relating to the bathrooms and the decks and the podium and the canopy roof. But most of the evidence the court heard was in relation to really complex structural defects and fire defects. And a lot of that evidence was expert evidence based on modelling how the structure would perform in the plaintiff's expert's opinion in seismic events and fires. The sums involved were enormous. They remain enormous, revised many times, described as a colossal case by the judge in her judgment. As yet undetermined, I'll come to that at the end, given the plaintiff's partial success. But we got a 469-page liability judgment in March 2024. Quantum's yet to be determined. That's in circumstances where there was no order for bifurcation. The plaintiffs advanced their full claim at trial in relation to liability and remedial scope and quantum, but because they didn't get home on everything that they were advancing against the council, and because they treated their claim for remedial works on a global basis, the court has only gone so far as making liability findings and some preliminary findings on quantum. And as I come to later on, we've now got a quantum hearing which is parked until after the Court of Appeal hearing in relation to the liability findings, which is scheduled for August 2025. So I'll hand over to Charlene. She's going to talk about proving actionable defects.
Okay. Sorry, just having a little bit of slideshow issues. But the first, when looking at actionable defects, the first thing we need to all focus on is that it is the plaintiff's burden to prove that the defect exists. So just for those who might not necessarily be lawyers, I set out in this slide the burden and standard of proof. So the burden of proof in civil claims is on the plaintiff or the claimant. The defendant is entitled to put the plaintiff to proof on all points in issue. There is just a little catch with that. If you are going to put your plaintiff to issues on all, to proof on all issues, it would pay to actually make sure you can have some challenge in relation to whether or not they're able to meet that burden, because the reality is if you take every point and you don't win them, you could actually find yourself facing some significant cost award for putting the plaintiff to that onus of proving every single point when some of the points should have been clear on the face. So just a little bit to watch out there, but the defendant is entitled to put the defendant to proof on all issues. So when you're putting the plaintiff to proof, it doesn't mean that the defendant has to disprove what the plaintiff says. It's really about just proving that the plaintiff hasn't, or establishing that the plaintiff hasn't met their burden. So the onus only shifts to the defendant if an affirmative defence is raised. So for example, if the council is raising a limitation defence or a failure to mitigate, then the burden will shift to them to prove that a limitation exists or that there was a failure to mitigate. The standard of proof to which a plaintiff must prove its case is on the balance of probabilities. So this effectively means that if you've got an issue, you're really going to need to establish that matter exists to at least 51% or greater. So it's that's how to informally look at it. But it's really just saying that it's more likely than not that that set of circumstances or facts will occur as has been submitted. Where a party fails to discharge the burden, it will lose on the question and issue. So if it can't reach that 51% or greater threshold of saying more likely than not, then the plaintiff will not meet that burden and prove their standard. So as we've said, the plaintiffs didn't succeed in Gore Street on all of its claims. So in the claim, there was 13 core defects. Some of those were divided into some sub-defects. But of those 13 defects, only 3 of the defects were held to exist in full. 6 defects were held to only partially exist, and 4 of the defects were held to not exist at all. So, but I think it's important to note here that there was, didn't mean that the council was liable for all of the defects that were held to exist or partially exist. In fact, the council was only held liable for 2 of the defects that fully existed, and then it was also held liable for 4 of the 6 defects that partially existed. So once limitation was, and that was on the basis of limitation. So the council, even though the defects were held to exist or partially exist, the plaintiff's claim was actually statute barred because of the affirmative defence by council that there was a limitation in play. Most of the limitation was around the 10-year building long stop limitation, but there was one success in relation to the 6-year limitation. So, so it was only ultimately that the plaintiffs failed to establish liability against the council for 7 defects. But when we're talking about the 7 defects, it is only 2 of them in full. So I'm sure Matthew will cover that a bit more. So what went wrong in terms of proof of the defects? So really I'm going to explain to you why the burden wasn't met by the plaintiffs. What may amount to an actionable defect may be different depending on the cause of action and the nature of the defendant. So really here is looking at the distinction between if it is somebody involved in the construction or if you're looking at the standard that would be for the council. So the council is sued in tort, not in contract. So its obligations may be assessed very differently to a builder who, say, has to comply with plans and specifications, whereas the touchstone of the council's duty is really about whether or not it's met its whether or not its acts or omissions has resulted in a failure to meet for the building system to comply with the building code. And then, so we've just set out the paragraphs there in relation to Spencer and Byron and the discussion in Gore Street on what the actionable claim against and the standard for the council. So while the plaintiffs could establish non-compliance with some of the construction work, and this was mainly to do with the fact that a lot of the construction work didn't comply with the technical literature, it did not prove on the balance of probabilities that the as-built construction was non-compliant with the building code. So there was 2 things being looked at here. One was non-compliance in construction, but did that mean that the building was, or the building systems went okay? And this was particularly the case with clause C of the building code. So just by way of an example here, we've got defect 2, and really what the plaintiff's evidence was focused on was technical issues that where the construction had not complied with the technical literature. And in the photo, you can see a screw where the metal stud has been fixed to this top track. So it's circled there with the showing the studs going through. And then also what was an issue was whether when that top stud actually hit the top of the stud hit the top of the track, which meant that there was no gap between the track and the stud. So if there was a fire, and because this is metal, it will expand in a fire, that the stud would have nowhere to go if it started expanding, which would compromise the wall and the integrity of that wall structure. So therefore, if the wall was affected, then smoke and fire could pass through. So if it created holes in the wall, or the wall actually deformed, that fire and smoke could track through, and therefore there wouldn't be an ability for the walls to maintain their integrity in a fire event. So what actually happened in the case of the plaintiffs relied on modelling to say what would happen, or what could happen in a fire event, and the court didn't actually agree with the plaintiffs. They said that the modelling didn't indicate what actually would happen, and so this was chiefly because of the fact that plaintiffs had actually relied on quite onerous fires. So when doing the modelling, they were looking at what type of fire would occur in the complex, and then they would model that heat and of that fire that would be generated and how it would impact on the building element. Whereas what the council concentrated on was more of, would the ultimate wall construction mean that there wouldn't be an expansion to the steel framing, and therefore those issues that the technical non-compliances would actually not be an issue, because you wouldn't have the expansion of the steel studs anyway, because of the wall construction. Despite the non-compliances, the court didn't accept that there was any breach of the building code. And just to quickly touch on a recent decision also in Bianco, although the fire wasn't dealt with ultimately in the case, what happened, because that was actually settled out just at the start of the hearing, in that case, there was construction of the as-built wall, and that was tested in a fire test in a fire furnace. And the specimen itself had all the defects that were being alleged. And when it was tested in the fire furnace, what actually happened is that the fire wall actually maintained its integrity. And so it actually it was required to perform for about 30 minutes under its FRR, but it actually far exceeded that. So I'm just going to quickly touch on actor omissions, really just highlighting the point here that if a defect had been held, then the council would have had liability, because the court held that the council should have, during its inspections, picked up on these non-compliances with the technical literature. It should have been aware of the technical literature, because that was what was required to be complied with under the consent, but it didn't pick that up, and therefore it was negligent in undertaking its inspections. But the council was ultimately not held liable, because those failings to pick those issues, technical literature issues up, meant that there was still no breach of the building code. So therefore there would be no loss to the plaintiff, because there was not a issue with the actual construction and its performance.
Thanks, Charlene. I think Lauren's given me about a 4-minute warning, so I'll just do a whistle stop tour through the approach to quantum. Just if you go to the next slide, Charlene. So, I mean, this will be well known to you, but the measure of loss is the cost of repair, or loss in value if it's not reasonable to repair. Plaintiffs, as is common, sought costs of repair. The critical point is that they advanced their claim in relation to quantum based on a global scope of works and a global tender price for one contractor to complete that as one big remedial project. $157 odd million was the total claim, most of which was made up of the cost of remedial works. The challenges with that approach seem obvious now, but so, you know, obviously it was premised, the idea of a global scope of works in quantum was premised on the council being held fully liable for all 13 defects. There were major challenges to the liability in relation to each of those 13 defects at a series of levels. The breach of duty, the duty of care was accepted. That's well established in the case law, and the physical realities of the building weren't really in dispute in terms of what the plaintiff's experts had observed in their investigations. But major challenges to whether the defects were in fact defects, if they were, whether they breached the building code, whether the council had breached its duty, causation and limitation. And it was very clear from the expert evidence that there were majorly divergent views among the experts. And I set out a quote from paragraph 3 of the judgment, the last sentence of which reflects that. Her Honour called it a palpable feature of the case. And the plaintiffs maintained that position on the basis that if they had costed the defects on a defect by defect basis, that would be inconsistent with their theory of the case. So where things ended up, Charlene's already talked about this on one of her slides, but there was very mixed success at trial in relation to the defects. The council was fully liable for 2 defects, and those were the traditional weather tightness defects to the podium and the canopy roof. Mostly found not liable for the complex defects, and that was important because those were the defects that were driving both the remedial program, which was premised on stripping the building back to its concrete frame effectively in order to fix the structural defects, and so driving most of the quantum. So what the court said was, well, that was a pragmatic approach because it made sense to fix everything in one go, but it was inutile, which I had to look up, means useless or pointless in a circumstance where a defendant isn't liable for the whole remedial program. So where the court got to was that, well, they didn't fail to prove their loss. That was one option, and one that we suggested the judge seriously consider. But the remedial cost claim needs adjustment to reflect the partial success. In the meantime, as I think I said in the introduction, there's been appeals and cross appeals to the Court of Appeal that are being heard in August 2025. There was a big argument before the judge about whether we would deal with quantum before the appeals, or even whether we could deal with quantum before the appeals, or whether it should wait for the outcome of that. Just picking up on the next slide in the last minute or two I've got, judgment on 30 July 2024, essentially the judges put the matter on hold in the High Court until the disposal of the appeal and cross appeal, and possibly any appeals to the Supreme Court after that. What's not clear at this stage is what the parameters are for that quantum process, whether the plaintiffs get what we call a do-over on quantum, or whether they're limited to the evidence that has already been produced. And so just quickly rounding out on the slide, didn't want to give any answers, but just provoke some thought on it in terms of the implications of that. One is massive delays. Construction finished in 2006, proceeding began in 2014, trial was in 2022, and it seemed unlikely the quantum process is going to resume in the High Court for a long time. I've put a question mark there because we just don't know, but it's not going to be before, say, 2027, and possibly later if there are subsequent appeals. There's going to be argument regarding the scope of the exercise once the Court of Appeal has issued judgment, potentially another round of appeals regarding the eventual quantum judgment after that, which is a common feature of bifurcated trials. So just to provoke some thought around that, alternatives, again, not suggesting any answers to this, just some options. Should bifurcation of liability and quantum been seriously considered from the outset, despite that there's a heavy onus on an applicant for that order? Should there have been a different mechanism for adjusting scope and quantum in circumstances where it was always likely that there was going to be mixed success? Or should parties generally be held to the litigation strategy that they adopt? The plaintiffs here took a risk of advancing a global claim which didn't succeed. So I'll hand back to you, Lauren. Thanks very much.
Thank you so much. I'll just move swiftly to our next speaker, just so we don't run out of time. So next we have Rebecca Saunders. She's a partner with Wynne Williams, who regularly advises on matters relating to payment, cancellation, variations, delay, defects, and certification. Rebecca has a particular expertise in resolving construction disputes under the CCA. She's going to discuss When You Know You're Out of Time, the recent decision in Ferrier and Auckland Council. And Rebecca, I'll hand over to you.
Thanks, Lauren. And good afternoon, everybody. Thanks, Madison, Matthew and Charlene for your informative sessions. I'm afraid I don't have a fancy slideshow. If I didn't have my blinds down, I'd be inviting you all to take a good look at the Gore Street apartments that we've just heard about, which are immediately behind me. Otherwise, I'd encourage you to have a look at the decision in Ferrier and Auckland Council, which you should have. Or as I say, DIY slideshow, open up section 14 of the Limitation Act 2010, because that's what I'm going to talk about. As I am the last speaker today, I thought this case law update needed a pithy title, when you know you're out of time, to draw you all into a talk on the dreaded topic of limitation. Now, I say dreaded with good reason, because, as many of you will know, the affirmative defence of limitation, if successful, is a complete defence to a claim. The thought of missing a limitation deadline when acting for a plaintiff, or conversely, not getting the advantage of a limitation period when acting for a defendant, strikes fear into the heart of any construction lawyer. The big question most of us have to grapple with in this area is when time starts to run from for the purposes of the limitation clock. And the recent Court of Appeal decision in Ray and Auckland Council provides some much needed judicial guidance on this point. To provide a quick overview of the way the law in relation to the limitation of actions operates here in New Zealand, generally speaking, plaintiffs have 6 years from the date of the act or omission on which the claim is based to bring a claim, subject to the 10-year long stop for civil proceedings relating to building work under Section 393 of the Building Act 2004. So there's 2 Limitation Acts to be aware of here. The first is the Limitation Act 1950, which applies to acts or omissions prior to 1 January 2011 and limits actions after the expiry of 6 years from the date on which the cause of action accrued. And then we have the Limitation Act 2010, which applies to acts or omissions from 1 January 2011 onwards and limits actions brought 6 years after the date of the act or omission on which the claim is based. This is known as the primary period. The Limitation Act 2010 adds a further limitation period of 3 years after the late knowledge date as defined in Section 14 of the Act, and that's what I'm going to focus on today. For the purposes of today, all you need to know is that there are subtle differences in the application of the 2 Limitation Acts, and that the Ray decision is focused on the more recent 2010 Act, and in particular, the application of the late knowledge period as defined in Section 14. So, for those of you doing the DIY slideshow, if you could open Section 14 of the Act, that provides that a claim's late knowledge date is the date after the end of the claim's primary period, on which the claimant gained knowledge, or, if earlier, the date on which the claimant ought reasonably to have gained knowledge of a number of facts, and there's a list of A to E. And A is the fact that the act or omission on which the claim is based had occurred. So in the case of a council, the fact that the council has issued a building consent, undertaken inspections, or issued a co-compliance certificate. B, the fact that the act or omission on which the claim is based was attributable wholly or in part or involved the defendant. And C, if the defendant's liability or alleged liability is dependent on the claimant's suffering damage or loss, the fact that the claimant had suffered damage or loss. Importantly, a claimant does not have late knowledge of a claim unless the claimant proves that at the end of the claim's primary period, the claimant neither knew nor ought reasonably to have known of all of the facts specified. So, yeah, so a bit wordy, and as I say, I'd encourage you all to have a good look at that. So why have the late knowledge period? I hear you all ask. Well, in preparing for today, I did take a quick look at Hansard. Parliament recognised the difficulty caused when a current limitation period ends before a person knows enough to consider bringing a claim. The late knowledge period is intended to apply after the primary limitation period has expired in cases where the claimant has not known and could not reasonably have known the key facts required to make the claim within the primary limitation period. The late knowledge period starts on the date when the claimant has gained or reasonably ought to have gained knowledge of the key facts, and it runs for 3 years. And in the parliamentary debate, the fact that there was a long stop period was seen as positive here. So, what was the decision in Ray all about? Well, Mr. and Mrs. Ray purchased a property in Te Atatu, here in Tamaki Makaurau, on 11 February 2014. The property was developed by 360 Degrees Limited and built by Tony Cathro Construction Limited. Both entities are parties to the proceeding, along with the council. The council issued a building consent on the 12th of December 2012. The council issued a co-compliance certificate on 18 October 2013. About 6 months after the purchase, the Rays became aware of minor aesthetic issues with the property and made a claim under a master build guarantee. In 2016, Master Build engaged Maynard Marks to undertake inspections. Maynard Marks identified 31 internal, external and structural defects. Maynard Marks in turn engaged ACH Consulting Limited to carry out a structural review of the property. ACH identified structural weather tightness defects, and that all occurred in around 2017. Later, the Rays engaged Fraser Thomas to undertake further investigations. Fraser Thomas report dated 19 March 2019 recorded further structural defects and extensive workmanship issues. In September 2021, the Rays filed proceedings against various parties, including the Auckland Council, claiming costs to repair defects. The Rays alleged that the council had been negligent in relation to the issue of the co-compliance certificate, which was issued on 18 October 2013. Now, the council managed to strike out the Rays claim in the High Court on the basis that it was time-barred and that the alleged acts or omissions of the council occurred on or before the issue of the CCC, being outside the period before the Rays filed their claim, the limitation period. The Rays appealed to the High Court of Appeal, arguing that the time in which a claim could be brought was extended by the late knowledge provisions in the Limitation Act on the basis that the Rays were not aware of the extent of the defects until the Fraser Thomas report of 19 March 2019. The Rays argued that the late knowledge date was the date of the Fraser Thomas report, as that was the report that identified the magnitude of the problems and identified a number of defects that had not previously been identified in earlier reports. The issues on appeal were what is required for the Rays to have late knowledge under the Limitation Act, and in particular, what is the act or omission on which the claim against the council is based? Do the Rays require knowledge of a causal connection between the act or omission on which the claim is based and their loss or damage? When did the Rays gain actual or constructive late knowledge? And are any of the Rays' claims against the council fresh causes of action that are not time-barred? In relation to the first point of appeal, the Rays argued that Section 14.1 required the Rays to know actually or constructively that there were breaches of the building code, and those breaches were matters the council ought to have identified, and that those breaches were causative of the losses suffered. In addition, the Rays submitted that Section 14 requires a claimant to have knowledge of all the facts necessary to bring a claim. From the Rays' perspective, the reports from Maynard Marks and ACH Consulting identified errors by the builders, but did not identify errors by the council. Therefore, it was not until 19 March 2019, being the date of the Fraser Thomas report, that the Rays could have known or reasonably have known of the defects at the property. As the Rays commenced proceedings in 2021, on this analysis, the claim was brought within time. The Court of Appeal disagreed with the Rays in their particular interpretation, in holding that the words act or omission on which the claim is based have their plain and ordinary meaning. The court rejected the submission that a claimant needs to know all the facts necessary to show that the council has breached the duty to exercise reasonable care and skill in the performance of its building control functions under the Act. All that is required under Section 14 in this case was knowledge that the CCC had been issued. The court went on to hold that the text of Section 14(1)(c) makes it plain that the only fact of which knowledge is required under this limb is the fact that the claimant has suffered damage or loss. Those words do not convey, even implicitly, any requirement for knowledge of a causal link between the defendant's act or omission and the loss or damage. The court went on to conclude that, in this case, the act or omission on which the claim is based for the purpose of Section 14 is the issuing of the CCC by the Council without more. Damages for the purpose of Section 14(1)(c) will exist if there are defects that are noticeable and not minor. In terms of the all-important question of when a claimant will have constructive knowledge, the court held that this will occur if they have information that would lead a reasonable person to begin investigating whether a right to claim exists. They cannot close their eyes to the obvious. They cannot postpone taking action if a reasonable person in their circumstances would take action. So the court found that by the 23rd of March 2017, being the Maynard Marks time, the Rays had either actual or constructive knowledge of the relevant facts, namely, the CCC had issued on 18 October 2013, the house had defects that were potentially breaches of the building code, and repairs would be required. That was all that was necessary. Knowledge of these facts would have led a reasonable person to undertake further investigation, including obtaining legal advice, and therefore it was by that date that the Rays had the required knowledge for the late knowledge date under Section 14(1). It follows that the claim brought in 2021 was therefore time barred. Just in terms of the third point of appeal, the statement of claim filed by the Rays did not particularise the loss claimed in relation to the different defects at the property, but like Gore Street, and rather all the defects were pleaded together. Counsel for the Rays argued that some of the defects were sufficiently separate and distinct to amount to a fresh cause of action, which is not time barred. The Court of Appeal rejected this argument on the basis that no draft pleading showing how the pleading would be amended to show the new causes of action was provided. In addition, all but one of the structural defects identified by Fraser Thomas in their 2019 report were identified by ACH back in 2016. So based on the evidence before the court, there was nothing to suggest a new cause of action that would not be time barred. So, a tough decision for the Rays, but a decision that will be welcomed by Auckland Council and other territorial authorities, I'm sure. Having said all of that, I am reliably informed by counsel for the Rays that they have applied for leave to appeal to the Supreme Court, and that we can probably expect the Supreme Court decision on the question of whether or not to grant leave to be released this side of Christmas. Thank you, Georgina Grant. Georgina has also kindly pointed out that there are other strikeout decisions under the Limitation Act 2010 coming down the pipe, including a decision of Associate Judge Lester in Christchurch from just a few days ago in Baxter and Eaton, where a plaintiff's claim concerning building defects was not struck out based on a similar late knowledge argument. I've yet to consider that decision closely, but I note it concerns a claim in contract rather than in tort, which may potentially have some bearing on the outcome. And it concerns information provided as part of an information pack before entry into agreement for sale and purchase. The other point just to make is that just because a strikeout doesn't succeed, a strikeout application doesn't succeed on limitation, doesn't mean to say that it won't succeed later at a substantive hearing. And I just to round that all out, it seems that all of these cases will be very much fact dependent. They'll all turn on their own facts. One thing is for certain, limitation will remain a hotly contested area given the stakes are so high. So grab your popcorn and watch this space. That's all from me.
Thank you so much, Rebecca. Again, very excellent and topical discussion. This concludes our case law presentations. So thank you again to all of our presenters today, Madison, Matthew, Charlene, and Rebecca, for your thoughtful presentations, and to Minter Ellison for hosting us today. And there'll be a token of thanks from the Society of Construction Law coming your way. And thanks for everyone for joining us online. Just a reminder to register for Michaela Cook's meeting next week. I was just going to check if there are any questions, and I think we're out of time and there are no questions anyway. So that's it. So enjoy the rest of your day, everyone. Thanks again.